Welcome back, folks, and on to our discussion of Chapter 3, Federalism. Take just a few minutes and watch the American Government Crash Course mini lectures number 4 and 5. The link is posted on the main D2L page. It's also in the syllabus too. Okay, here are learning outcomes for the week. We'll define the following governmental systems: federal, unitary, and confederal. We'll list and analyze the benefits and weaknesses of the federal system. We'll recognize how provisions of the U.S. Constitution provide the framework for federalism. We'll identify how the U.S. Supreme Court confirmed the authority of the national government and how that authority was solidified after the Civil War. We'll define the terms dual federalism and cooperative federalism, and we'll analyze Supreme Court rulings that impacted the distribution of power between the national government and the states. All right, the systems of government that we see around the world. Unitary systems, these are the most numerous. This is what we see in most places. Centralized government, where local governments exercise within powers granted by the central government. So it doesn't mean that there isn't regional government, doesn't mean that there's not local government, but they are under the command, under the ultimate control, under the ultimate authority of the central government. Some examples of that would be the United Kingdom, Sweden, Japan. Pretty much any authoritarian state by nature is going to be a unitary system. Confederation, we discussed confederations last week. The United States began as a confederation under the Articles of Confederation. It's a league of sovereign states that delegate limited power to a government, central government. But most power remains in the hands of the independent states. They retain sovereignty in most areas. And of course, after the Constitutional Convention and its ratification, the United States became a federal system where power is clearly mapped out by our written Constitution. It's divided between the powers of the federal government and the powers of the states, and that again is mapped out in a written Constitution. And here's the graphical overview of what I was just discussing. I know this is in your text as well. So why go with federalism? Why go with a federal structure of government? Well, first, it's a practical solution to satisfy those who want a strong central government and the benefits of the strong central government, and those who advocate for state rights and home rule and the ability to govern yourself at the local and regional level. So it's kind of balancing those two interests. Now, U.S. geography makes it difficult to locate all authority in one place or to have too much centralized rule. And this was particularly the case in the early years of the Republic, right? Because there wasn't transportation systems, there wasn't communication systems that would allow a central government to govern effectively. So it was an absolute necessity then. But even now, the huge population differences in the United States, the cultural differences from place to place, make for many different cultures and environments, and so it would be pretty difficult to run a centralized government out of one spot. State governments historically train future national leaders, so they're kind of a training ground for that. Many presidents had a background in serving as governor. In fact, President Trump and President Obama were unusual in the fact that they both didn't have that experience. President Trump didn't have any governmental experience whatsoever. And President Obama had served in the United States Senate and in the Illinois Senate, but had not served in an executive position at the state level. That's kind of unusual. Many presidents served as governors. Bill Clinton from Arkansas, Ronald Reagan, California, George W. Bush in Texas. State governments also serve as a testing ground for policy initiatives. So many things that ultimately are adopted at the national level were tested out at the local level. For example, the Affordable Care Act is based largely on healthcare policy that came out of Massachusetts. Many states right now in the United States are testing legalized marijuana and seeing sort of the broader impact on that. We'll see if that's reflected in national law at some point. So there are many examples where initiatives are tried at the state level, and if there's some success with them, then they might be adopted perhaps in other states and then ultimately at the federal level. Again, federalism allows for many political subcultures. What that means is that at the same time there is a federal government in Washington, D.C., it allows Texas to be Texas and Minnesota to be Minnesota and Hawaii and so forth. And they can have their own policy initiatives. They can have their own educational initiatives and healthcare initiatives and that kind of thing. Now, there are downsides. Powerful state and local interests can block national plans. We also saw this with the Affordable Care Act, where some states did not want to fully implement the Affordable Care Act, in particular providing expanded health care, expanded Medicaid, to poor people who qualified for it. So part of the Affordable Care Act was to provide additional health care benefits to people who could not afford health care. Some states did not implement that component, and the Supreme Court ruled that they didn't have to. So the implementation of the Affordable Care Act was pretty uneven. And we do tend to see a great deal of inequity across the United States in terms of healthcare, in terms of education. So by allowing different states that have different levels of resources to do their own thing does create inequality between states. And so federalism, while there are many positives associated with it, it does create a much more uneven government services across the United States. The state-federal relationship is another check and balance in our system. We often think of the checks between the judiciary and the executive branch and the legislature as the checks and balances in American democracy, but also the relationship between the federal government and state governments. For example, in many cases, the federal government will sue states for being in violation of the Constitution, or states will sue the federal government in federal court as exceeding its constitutional powers. And in many cases, the federal government or the state government will prevail. Somebody will prevail. And that will check either excesses at the state level or excesses at the federal level. We also need to take a step back and recognize that, the framers of the Constitution didn't really see the states as subdivisions of the national government. That is, that from their perspective in the early years of the Republic, and certainly at the Constitutional Convention, was that states held sovereignty. They were independent in many ways, if not most ways. They were considered to be sovereign, and they were giving up a degree of sovereignty for certain necessary national powers. Over time, more and more powers were assumed, and in some cases granted to the federal government, as the United States became more interdependent, economically powerful. And we'll talk about some of the reasons for that as we go. All right, let's talk about how the Constitution provides for federalism. Powers delegated to the national government include both enumerated or expressed powers. And enumerated means that it's clearly in the Constitution. And implied powers would mean that courts and precedent has implied a federal or congressional power. Implied powers allow the federal government to make decisions that fall outside of the purely expressed powers. This comes from Article 1, Section 8 of the Constitution, the elastic clause, also referred to as the necessary and proper clause. And so it allows Congress to do what's necessary to carry out its delegated powers. So let me give you an example of this. Congress has the power to tax. This is a concurrent power that states also have. So we have state taxes and we have federal taxes, right? Now, there's nothing in the Constitution that says Congress can create the Internal Revenue Service, or IRS, to collect taxes. There's nothing in there that says the IRS should be created, okay? But Congress has the power to tax. So they therefore have the power to create an agency to collect taxation. So you might be sitting there saying at the end of the year, well, I don't want to pay my taxes, and there's nothing in the Constitution that says the IRS is even lawful, so I won't pay my taxes this year. That's a bad idea. You still have to pay your taxes because Congress has the power to tax, and by virtue of that, they have the power to create institutions to collect taxation. So hopefully that makes sense. Inherent powers are those that are just simply necessary for a sovereign power, a sovereign state like the United States to exist. So, for example, it is assumed that the federal government will be the one to carry out diplomatic relations with other nations. That's an inherent power that goes with being a state in the international system. And I use this term already, but concurrent powers are those that could be held by both the state and the federal government. So some forms of powers that are in the federal government are specific to the federal government, like relationships with other nations. Others are concurrent, like taxation. And some things are purely in the hands of the states. For example, in the United States, it is only the state governments that have the power to actually conduct elections. We do not have a federal government that conducts elections. Certainly, if a state violates other laws related to equal protection and protecting those groups that have been historically marginalized, that a state can violate those laws as part of their election procedures, but the federal government actually does not have the power to conduct elections. States do not have the power to make their own currency. So the state of Minnesota cannot decide, hey, we want to start printing Minnesota money. That is a specific power, that is an enumerated power that belongs to the federal government. Let's talk just a bit about the Supremacy Clause in the Constitution. This is Article 6 of the U.S. Constitution. It's often misunderstood, but it states in general that the U.S. Constitution is supreme in those areas where there's conflict. So, if the Constitution spells out something, for example, that the federal government has the power to make currency, to coin money is the expression used. A state cannot just say, well, we're going to make our own money, all right? Then you would have a conflict between a federal law and a conflicting state and local law. Now, that doesn't mean that the federal government is always dominant or always wins, because rarely are things quite so clear. A state can sue the federal government saying that it's exceeding its powers, that the Constitution does not give them the breadth of power that the federal government is assuming. And in many cases, the states will win. Those cases will go, in many cases, all the way to the United States Supreme Court. And the United States Supreme Court will side with the states over the federal government. So it doesn't mean that the federal government is always supreme. It means that ultimately, if there's a conflict and the federal government has a clear legal power, the states cannot just declare that null and void. The states can challenge it in court, but once the courts have ruled, and ultimately once the Supreme Court has ruled, the states need to accept the outcome of that decision. So the Supremacy Clause has a little bit more texture than simply the federal government is always right. This is an outline of the different powers that are enumerated for the federal government, express powers for the federal government, as well as the states, and those concurrent powers where powers overlap. So again, to coin money is a specific power assigned to the national government. An example of a concurrent power would be to levy taxes, something that's reserved specifically to the states to regulate commercial activity specifically within that state. The federal government has the power to regulate commerce between the states, and that's where there's a great deal of power allocated to the federal government. It used to be most commercial activity would happen locally. It would happen not even just within your state, but within your community. Now we know that much commercial activity goes across state borders. In fact, most commercial activity goes beyond state borders, and that gives the federal government a great deal of power when it comes to regulating our economy. And the Constitution also has measures that specifically limit state governments and the national government. So the national government can't tax things that are exported from any state. State governments can't grant titles of nobility. State governments likewise cannot tax imports or exports. So the Constitution also has some measures that specifically limit the powers of government at the state and the federal level. The Constitution also addresses relations between states or interstate relations. There are three important clauses governing this in Article 4, Sections 1 through 3. Number 1 is to recognize other states' public acts, records, and judicial proceedings. Number 2, extend other state citizens the rights of its own citizens. And 3, agree to return people fleeing from justice to their own state when requested. Now, Number 1 was particularly important when some states allowed gay marriage and others did not. Now, ultimately, the Supreme Court ruled that there was no legitimate reason to deny marriage equality, and that legalized gay marriage nationwide. But before that, some states allowed gay marriage and some states didn't. For example, Iowa allowed gay marriage, but Minnesota didn't. And because Minnesota is a bigger state than Iowa, you had more people who were gay couples getting married in Iowa than you actually had Iowans getting married. So you had more Minnesotans going down there to get married than you actually had Iowans within the state who were getting married. Now, why does that matter? Well, number 1 says that each state needs to recognize other states' public acts, records, and judicial proceedings. So that means a marriage in Iowa must be accepted in the state of Minnesota. So some states that were more conservative, they didn't like the fact that gay couples could go to another state, get married, and that had to be recognized, or at least a literal interpretation of this component of the Constitution would suggest that that would have to be recognized. Now, again, ultimately that was dealt with the Supreme Court ruling that protected marriage equality. Article 2, extending the rights of other state citizens, the rights of its own citizens. This actually has some murky areas into it. I mean, one thing's make clear, you shouldn't have a separate judicial system. You shouldn't face additional penalties just because you're from out of state. You should be able to seek work, seek employment, use the same roads, use the same parks. But there is some areas of gray. For example, many universities will charge in-state and out-of-state tuition. And some people have suggested, well, wait a minute, are you not extending to other state citizens the rights of its own citizens? Ultimately, the courts ruled that that was a legitimate way for states to, specifically benefit people who had invested in that state's university and college system by having in-state and out-of-state tuition. State like Alaska will give its citizens a share of the oil revenue from that state because they make a fair amount of money in oil. Some people have suggested, well, hey, wait a minute, shouldn't I be entitled to that? Taking a look at Article 4 of the Constitution. And again, in that situation, the courts have ruled the answer is no. So you cannot just fly up to Alaska and ask for your share of their oil money. And number 3 is pretty straightforward. Agree to return persons fleeing from justice to their own state. So if you think, oh, hey, I'll go commit a crime in Wisconsin and run back to Minnesota and no problem. No, that's not going to work. Spend some time in your reading understanding these foundational Supreme Court cases that establish the powers of the national government. McCulloch v. Maryland establishes the idea of national supremacy, that national law is supreme to state law, and that state laws cannot be created to thwart national policies or the federal government. Gibbons v. Ogden establishes the power to regulate interstate commerce as an exclusive national power. This is a big deal, and it's grown in power over American history. The ability to regulate commercial activity as long as it goes across the state border. Most commercial activity today crosses state borders. That wasn't the case in the early years of the Republic, but it's certainly the case now. So establishing that power for the federal government is one of the reasons why the national government has grown in power. Both of these are decisions made under John Marshall's Supreme Court leadership as Chief Justice as a Federalist. He built up the court as an important check to the elected institutions, the elected branches of government, and created and reinforced the idea of judicial review, the ability of the Supreme Court and the federal courts to review the laws and actions of elected branches of government to determine whether or not they were constitutional and lawful. That's a great deal of power in a court system, and something that's not specifically mentioned in the Constitution. That was developed with legal precedent, with tradition, and a lot of it had to do with the long-serving Chief Justice John Marshall establishing this concept of judicial review. And on to a brief historical overview of federalism in the United States. Of course, in the early years of the Republic, federal powers expanding under the leadership of John Marshall and American presidents that are seeking to expand the power of the federal government. There's pushback during the Jacksonian era as Andrew Jackson gains political power, ultimately the presidency. This is also the build-up to the Civil War. The idea of nullification is put forth in southern states, the idea that states could declare a national law null and void if they didn't like it. Of course, this flies in the face of the Supremacy Clause of the Constitution. And South Carolina does this initially against the federal tariff, claiming that in cases of conflict, the state ultimately had authority when in conflict with the federal government. This builds up to succession when nullification, the constitutionality of that is declined by the court system. And so in 1860, we see 6 southern states secede from the Union. This is largely around the issue of slavery, right? Under the broader umbrella of state rights. And this leads ultimately to the Civil War. Now, you probably know how the Civil War ended, so spoiler alert, the North won that one. And the defeat of the South ends this concept that states could secede, also ends the concept of nullification. And ironically, the defeat of the South and the Confederacy results in expansion of federal powers, which is just the opposite of what they were fighting for. You've got a larger federal government, in part because the federal government always expands during times of war, during times of conflict. So you have larger bureaucracy to conduct the war effort, and then in rebuilding the South and the country under Reconstruction, and also to provide pensions for veterans from the Civil War. Of course, only Northern veterans. Confederate veterans did not get a pension of any kind. You see the first $1 billion budget pass. You see the first income tax imposed. It's a temporary income tax, but still. So you're seeing an expansion of the power of the federal government after the Civil War because of the Civil War, which is precisely exactly what the South was fighting against. Okay, moving on. Let's identify and contrast some different views of how federalism should function. You have the idea of dual federalism. This is the idea that the national government has certain responsibilities and the state governments have certain responsibilities. They're equal in sovereign powers, and they don't interact that much. They have different areas of responsibility. The states will, perhaps provide education, and the federal government will perhaps provide for national defense, and there's not a lot of overlap. And this viewpoint obviously is something advocated historically by states' rights advocates and was prevalent during much of the 1800s. As we get into major crises of the 20th century, the establishment of huge monopolies in the early part of the 20th century, World War I, the Great Depression, World War II, the idea of cooperative federalism takes hold, that states and the national government should cooperate to solve problems, and there's not a clear separation between the powers of the federal government and the state government. So, for example, today, The federal government will provide grants for transportation that allow for the construction and maintenance of highways. But there are strings attached to these grants. The grants will require perhaps a certain drinking age in that state, and that's why we see across the country that 21 is the legal drinking age, and certain requirements on speed limits and safety and seat belt requirements, things like that, strings attached, regulations attached to that funding. This would be an example of cooperative federalism. And in the process, we see an expanded power of the federal government as the federal government involves itself in public policy at the state level. And this is an ongoing tension in the 20th century, not only in the recovery after the Great Recession and after World War II, but well into the 50s and 1960s. In the Johnson administration, see an expansion of federal authority, very ambitious, Great Society, referred to as the Great Society programs. If you're using federal student financial aid, that was a Great Society program under the Johnson administration, funding low-income housing, providing health care for senior citizens through Medicare, and providing health care for people who are poor through Medicaid. These are Great Society reforms. So we see an expansion of federal power and influence. But this is sort of the peak of federal authority when it comes to our federal system. Since the 1970s, we've seen a process we refer to as devolution, which is returning power to the states. This is pushed by Richard Nixon, who returned money to the states in the form of block grants that had fewer strings attached. Certainly Ronald Reagan, as he became president, he argued quite famously that government's not the answer, government's the problem, and perhaps overstating the point, but he was arguing that the federal bureaucracy had become too large, too burdensome, that these responsibilities and needed to be returned to the states. So from the 70s through the 90s, and not just under both political parties, under Democrats and Republican Party, we see a shift back to the power of state and local government. For example, under Bill Clinton, there was a great deal of policies that returned responsibilities to the state level and shrunk the size of the federal government, also shrunk the size of social programs, welfare programs. So welfare reform of the 1990s reduced that and gave more authority to the states, for example. You know, as stated before, the Supreme Court has a big role to play when it comes to the bounds of federalism. How powerful should the federal government be? What powers should be reserved for the states? And because the Constitution leaves a lot of room for interpretation, these lines are being drawn and redrawn. How powerful should the federal government be? And when it comes to issues of immigration, the Supreme Court has said that the federal government is in the driver's seat because the federal government conducts relationships with other countries. When it comes to healthcare reform, that's been kind of a mixed bag. Historically, the states have a lot of power to regulate healthcare. Under the Affordable Care Act, the federal government's role expanded, but the Supreme Court limited that and said that states did not have to participate in expansion of Medicaid, which is health insurance for the poor. However, they did say that the federal government could impose a tax to encourage individuals who could afford health care to get health care. So much of the Affordable Care Act was deemed constitutional by a conservative Supreme Court. Now that may change as the Supreme Court becomes even more conservative after the Trump years. Same-sex marriage has been something that initially was left to the states to decide, so that was a states' rights issue. But in 2015, the Supreme Court ruled that there wasn't a rational reason for denying marriage equality, and therefore deemed such restrictions at the state level as unconstitutional. So now across the United States, whatever state you live in, same-sex marriage is lawful. The Voting Rights Act, which was created in the 1960s, that enforced states that had a history of discriminatory practices toward racial minorities, That law said that the federal government needed to be able to approve any changes in their voting system to make sure that rules and regulations were not put in place to limit access to the ballot, to limit access to the polls for those who have been traditionally disenfranchised, particularly African Americans. Important parts of this act were struck down over the last decade, saying that this should be left up to the states, and that the states are being treated unfairly because those states that had a history of discriminatory behavior were being treated differently than northern states. Anyway, the Supreme Court struck this down, so you could argue that this would be an expansion of state rights. Affirmative action has been guided by the federal government, and limitations have been put by the federal government on the states as to what can be allowed for affirmative action. So affirmative action can be a factor when it comes to college admissions. Colleges and employers can spend extra resources recruiting people of traditionally underrepresented backgrounds. However, the Supreme Court has ruled that you cannot use quota systems saying, 20% of these jobs need to be reserved for this specific racial category. You cannot use point systems to elevate people based on their racial characteristics. So the federal government has provided some guidance when it comes to affirmative action that has limited state and local governments in their affirmative action policies. When we think of the politics of federalism, we often see it pretty simplistically, like that conservatives tend to support more states' rights, thinking that states are going to favor more conservative policies, and liberals are going to favor more power for the central government, believing that the national government is going to be more likely to promote progressive policies. But as I said before, this is a bit of an oversimplification. Sometimes states will promote more progressive policies, more liberal policies. We see this when it comes to marijuana legalization, for example. And under those circumstances, liberals, Democrats will make more of a states' rights argument. Particularly under the Trump administration, when there was complete control of the federal government by Republicans, it was often through federal policy, through a strong federal government, that they would push more conservative positions related to reproductive rights, related to taxation. So, whether you're Democrat or Republican, liberal or conservative, you tend to make a states' rights argument when that's convenient for you, and an argument for federalism and a stronger federal government when that helps, further your policy positions. All right, well, to sum up here, there's three models for ordering relations between the central government, local and regional governments, the unitary, confederal, and federal structures. Make sure that you understand those from your reading. The Constitution grants specific enumerated powers to the national government. We also call these expressed powers, and those are ones that you can read right there in the Constitution. But in addition, the Supreme Court has interpreted the Constitution to have implied and inherent powers that aren't specifically there, but are necessary to carry out the enumerated powers and the powers that are essential for a sovereign power in the international system. Understand the important role that Chief Justice John Marshall played in the early years of the Republic to establish a powerful federal government with expansive interpretations of both the Necessary and Proper Clause, also known as the Elastic Clause, and the Supremacy Clause. Since the Civil War, U.S. federalism evolved from more of a dual federal structure where the responsibilities of the federal government were distinct from the state to much more cooperative federalism today. But this is, at certain times, federal power is expanding, and other times it's contracting. Depends on the needs of the country, whether we're in a time of crisis. As I say this today, the United States is recovering from a pandemic and a crisis, so you're going to see a heightened role for the federal government and probably policies that are going to lead to a stronger federal government during a period of time like this. And the United States Supreme Court is ultimately, they make those decisions when it comes to the line between state and federal powers. And so the balance of power of the Supreme Court, whether it's more conservative, whether it's more liberal, that can really play out when it comes to the power of the federal government and the powers of the states. And here are your discussion questions for the week. As with other weeks, 1 substantial original post that follows the grading rubric carefully, and 2 responses to the on-topic posts of fellow classmates. Please feel free to reach out to me with any questions or stop by during Zoom office hours. Have a fantastic week, and I'll talk to you soon.